Please be seated. We'll hear argument in 2462, Sirius XM Radio against Hegar.
May it please the court, Mr. Friedman will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you. Good morning, Chief Justice. Good morning, Your Honors. May it please the court. This case is not complicated. It's not confusing, and it's not even a close call. It relates to a very simple and straightforward statute that requires companies that are multi-state service providers to apportion their tax base using a service performance rule. This Court of Appeals decision down below should be reversed for 2 reasons. One is the statute's clear and unambiguous. The second reason is the controller's formulation, reformulation, reinterpretation of the statute is ambiguous, conflicts with the statute, and creates, frankly, havoc on multi-state service providers. I'd like to elaborate on both points. The first point, the statute that is at issue here, 171.103A2, has been with us since 1959. It's produced very little controversy, very few litigation as a result of its clear and unambiguous nature. It is typical for a service provider to know where its employees are located, where its equipment is located, and apportion its tax base based upon those factors. As a result, we've seen very little litigation, and we've seen a string of controller decisions, hearing decisions, and letter rulings interpreting that statute in a faithful way, up until 2013. We don't know what happened in 2013, but something changed. The controller decided to reinterpret the statute in such a way that it no longer looks to the place of the performance of the taxpayer service, but looks to the place of delivery, place of location of customer, place of the benefit received of the service, place of delivery of the service to customers both within and without Texas, in violation in the statute.
Did your expert exclude the radio devices and the decryption of the signal from its analysis of the fair value?
So we presented two expert witnesses at trial in front of Judge Jenkins. Judge Jenkins attributed a great weight to both of their testimony. The witness that testified to the taxpayer's business activities, where it performed its services, described the approach of looking to the taxpayer's creation of content and distribution of content.
Right.
And part of
that production, transmission, understand all of that, understand that by and large didn't happen outside of Texas. But isn't decryption dependent on equipment based in Texas?
So it did look...
And did your expert account for that at all?
So our expert did account for it in the distribution component of his analysis, Mike Starkey's analysis. He looked to decryption. Sirius XM does decrypt its signal, and it controls that decryption from places outside of Texas. The fins on cars driving down the highways here in Texas are not Sirius XM's equipment. They don't own that equipment. They're not responsible for that equipment. In fact, it was installed by auto manufacturers, sold by car dealers typically here in Texas to local Texas customers. None of that equipment in someone else's cars that is not owned by Sirius XM was included.
What about the technology?
The technology was included in Mr. Starkey's analysis, and that, of course, is maintained in New York and Washington, D.C.
So your view is the technology that permits the decryption of individual cars in Texas is not at all performing any service in Texas? So
our view is that in applying the statute, performance of the service, looking at the taxpayer's activities and where they are engaged in, there is a component of transmission that includes uplifting stations in Georgia and New Jersey, decryption technology that is also in those locations as well. But as it relates to subscribers' cars, not just here in Texas, of course, all throughout the United States, those cars are not owned by SiriusXM. They're not, SiriusXM's not responsible for them. It's not an activity of SiriusXM.
But do they manufacture the chips under license from SiriusXM?
Yeah, the chips are technology that are created as a result of technology owned by SiriusXM. And again, that's an activity that also takes place outside of Texas.
Well, but not if the chip's in Texas, and the chip's only in the car by virtue of a license from Sirius.
Yeah, the chips are manufactured by third parties and sold to car manufacturers, who in turn sell them to car dealers, who in turn sell them to each of us.
Which is exactly what Sirius intends, I assume.
It's part of their process of getting their service made available to customers, much like any other technology company allows for downstream access to their content. And that's frankly...
And the chip couldn't be in the car without a license from Sirius, right?
As a result of SiriusXM's participation in the creation of technology outside of Texas, that's correct, Your Honor. Yes.
If the consumer had a license under TGS Geophysical Company,
I'm sorry?
the use, if the use of SiriusXM radio wasn't contractual but was pursuant to some sort of a license, we would under the other prong about the licensing of technology, we would impute that value to users in Texas, right, under TGS Geophysical Company.
Yeah.
And so it seems as though here it's not a license, but it's akin to a license, right, because you're limiting access to your production and radio, but with wildly different outcomes in terms of the assessment of taxes.
Yeah, so...
And what would be the explanation for that?
Yeah, so Texas law has created different regimes to determine how to source receipts. And we in our bench brief, we showed a couple of them here. There's a separate rule for receipts from sales of tangible personal property. There's a separate rule for receipts from sales of services. And there's a separate rule from intangible property, which is that location of payor test that I believe you're referencing. There is no dispute in this case that the receipts that are at issue in this litigation are receipts from services. It's in the fact findings, and frankly, it's in the party stipulations that we also replicated in the bench book.
But the service, a license is, in a geophysical case, was the use of information, geophysical information.
Sure.
And so why wouldn't we look to that as an analog for the fair value of the service provided in Texas?
So you don't have to, Your Honor, because the legislature did that for us. When they created these different buckets or different sets of rules for sourcing receipts, our first obligation is to determine what type of receipt are we sourcing. Is it a tangible personal property receipt, a service receipt, or an intangible receipt? Once the parties agree to the fact that this is a service receipt, once the trier of fact, once the Judge Jenkins determined that it is a service receipt, we are now applying 171-103A2, which is the service receipt rule. Once we're in that rule, we're looking to the place of performance, not the location of the payer. It is true, Your Honor, that many services do have an intangible component. Tangible sales, in fact, have a tangible component. If I were to buy a Wilson basketball, there's a Wilson trademark on that basketball. There's an intangible element to that basketball. It makes it more valuable than some other basketball, perhaps. But that doesn't change the fact that that sale of a Wilson basketball is a sale of a tangible good. Much like SiriusXM service is a service. Yes, there are some intangibles that are included in it, but that doesn't change the nature of the receipt. It's a sale of a service.
The comptroller says, your license is worth $2 billion.
Right. And
you attributed none of the value of that license to the subscriber base in Texas, even though 8% of the subscribers are located in Texas, and presumably the value of the license is dependent on the number of users of your services.
Yeah, this is.
And so why should we accord a valuation that leaves out the biggest asset of XM?
Thank you, Your Honor. So we presented a case at trial regarding those activities that are required for producing our services. Look at the costs associated with them, and then look at their location for purposes of applying 171-103A2, the place of performance statute. And in doing that, we had an expert come and testify as to how we did that. And he did, you're absolutely right, Your Honor, exclude certain things, such as our FCC licenses that we acquired from the U.S. government that enabled us to provide our service. What's interesting about that is a couple of things I wanted to share with you regarding that observation that the controller seems to think we didn't carry our burden. First of all, Judge Jenkins decided we did. He decided that we did carry our burden. He accepted the testimony from our expert witness. The second thing is those activities, those costs that were not included, that Mike Starkey, our expert witness, specifically excluded from his analysis were activities that he believed were support activities, activities that took place years before SiriusXM actually began its service. They acquired these FCC licenses years before actually providing its service. The third aspect, what happens if Mike Starkey, our expert, did include those FCC license costs? Well, guess what? They were included as costs in Washington, D.C. and in New York, where these companies were headquartered, where they negotiated with the U.S. government, where they paid for these licenses, where they amortized them. They're intangibles. They were maintained where the headquarters of these two companies, Sirius and XM, prior to their merger. So there was an attempt to only include those activities by Mike Starkey in our analysis that related to the actual performance of our service, and then look to where those activities were engaged in.
May I ask you, so let's say if we adopt the taxpayer's place of performance rule, but we reject that it's only in one place, when there's multiple steps involved, what test would you articulate?
Well, we have to remain faithful to the statute, and 171-103A2 is a clear standard that we cannot deviate from. 59, and it has not changed since. And
but what language are you referring to that says that it has to be only, it can't be a multi-step process?
It can be a multi-step process, Your Honor, and in fact, Mike Starkey's analysis reflects a multi-step process and in fact includes some costs here in Texas. We show an apportionment that is not zero on our tax return, even though the controller's briefing may suggest otherwise. Our tax return showed some activities here in Texas. We had 22 repeaters here in Texas. We had 4 hours of programming here in Texas as well. And we had programming in Nashville, Tennessee. We had programming in Orlando, Florida. We had programming in New York and in other places. And in each of those places, Mike Starkey looked at the costs associated with those activities and attributed those activities to those various jurisdictions. So for instance, he looked at the activities here in Texas and he assigned a cost and a location to them. Same thing in Orlando, same thing in Nashville. So we took the position that it is a multi-step process. It just so happens that we have, SiriusXM has very little activities here in Texas. And the controller doesn't like that, which motivated, we believe, the controller to change its position from its West
Why do you say they didn't like that? I mean, isn't it their duty to enforce the law as they see it? I don't see what the relevance of that is.
Thank you, Your Honor. It is not relevant. We entirely agree. The rules are what the rules are. So in Westcott, a company with facts, and you can see in our bench book tab 3, with facts identical, virtually identical, just in a different industry to our facts, satellite content, creating the content here, we created our content elsewhere. The controller took one position in that case in the 2003 Court of Appeals decision and reversed his decision here. Now, why would the controller do that? Well, in that 2003 Westcott decision, Your Honor, that position that the controller took by being faithful to the statute, look to the location of where the services are performed, produced a rather large apportionment, which produced a rather large tax amount. Applying that identical analysis to facts that are very similar, darn near identical, he changed his position because he didn't like the result, because this taxpayer has almost no activities, very small activities here in Texas. And that is not relevant. It shouldn't be relevant. That shouldn't be a justification for flip-flopping.
Should we interpret the use of service performed similar to the way it's used in the 1966 multi-state tax compact? I know they're not exactly contemporaneous, but how should we look at what other states are doing, if at all?
Thank you, Your Honor. The timeline is actually fascinating here. In 1957, actually, let me start there, this model statute that states were encouraged to consider adopting, called the Uniform Division of Income for Tax Purposes Act, that was drafted by the National Conference of Commissioners on Uniform State Laws, was created. And states were encouraged to create a uniform way of doing this. Now, Texas chose not to do it, ultimately, but let me get back to that in a second. That's 1957 is when that statute was first created, that model statute. 1959, Texas puts in place this statute. This 171-103A2 was put in place in 1959, which looks to service, place of performance of the service. Now, what's interesting is in that 1957 statute, 2 years before, they applied a rule for services in Section 17 of UDIP, Uniform Division of Income for Tax Purposes Act, that has an approach that is very similar to what Texas did 2 years later. Texas used different words to do it. In that 1957 UDIPA statute, Section 17, they looked at cost of performance and income-producing activities. Texas didn't use all those words. They just said for service providers, we're going to look at place of performance. And then what happened was many states adopted that 1957 uniform statute. It became the national standard. It was acknowledged by the United States Supreme Court over and over and over again as the quote-unquote benchmark for apportioning services that remains faithful to looking to the location of a service provider's activities, not the location of customers, which is the position that the controller is asking you to adopt today.
Is there any information in the record about what analogous taxpayers do? I know there's some in the amicus briefs.
Yes.
Anything else that's not in the briefs?
Well, the amicus briefs are super helpful regarding the concerns that are expressed both by companies headquartered outside of Texas and companies headquartered within Texas. And that is the havoc that is occurring here. So what happened in this case at the Court of Appeals, in the Sirius XM case, the Court of Appeals did not overturn its Westcott decision when it changed its position and was not faithful to the service performance statute and rewrote the law in its decision in adopting this location of the customer in the Sirius XM case. They left both in place, applicable to 2 satellite companies. So other service providers, and we all know how important the service part of our economy is, are looking at the Texas rules and are scratching their heads saying, which one do I follow? This applies to 2 satellite companies. I'm an internet hosting company. Well, we have a really bad answer as it relates to that question, because while this case was not final, while it was pending before this court, the controller changes its rule, goes final, and comes up with a laundry list of application of the service performance rule that abandons service performance. It is violating the statute. And if you look at, for instance, 3.591E13, internet hosting services, they look at the place of the customer. There's not even an attempt to look at the taxpayer's place of performance of the activities. They abandon it in its revised rule that they rammed through their administrative process while this case is pending. So,
any other questions? Thank you, Mr. Friedman.
Thank you.
We'll hear from the state.
May it please the court, Ms. Pettit will present argument for the respondents.
Thank you, Mr. Chief Justice, and may it please the court. Notwithstanding some of the comments that I just heard, the parties agree that Sirius's franchise tax liability depends on the location that it performs its services. They disagree about what those services are as a matter of Texas tax law. For decades, our law has looked to what at the end of the day the customer is paying to receive. And as Sirius's own chief engineering officer testified, consistent with its terms of service and its filings with federal regulators, Sirius's customers are paying to receive, and I'm quoting here, a seamless and ubiquitous listener experience available throughout the continental United States.
Let me ask you, if we adopt the taxpayer's place of performance rule, do you lose?
No, Your Honor, because what the dispute here is, again, is about the service itself. And the service here is does not occur until and as Justice Bland pointed out, the decoding of Sirius's highly complicated satellite signal in Texas.
And does the record indicate that about the decryption and that?
Yes, Your Honor. So Mr. Smith, their chief engineering officer, said at page 69 of volume 3 of the reporter's record, if we don't have a complete system, then we don't have a service. That's intuitive, because Sirius's customers are not going to pay for music that might be created in New York, but that they cannot hear.
So does Netflix pay tax on subscriber fees in Texas?
So, Your Honor, and this goes to the last point that opposing counsel just made about how the comptroller has adopted some new rule that's not tied to the statute. The legislature has actually amended the statute twice since the relevant tax period at issue here in 106 Section G and 106 Section H that specifically address internet hosting, which I believe would answer your question, that they are taxed based on their customer location per the legislature's instruction. They also expressly include...
So I guess I'm asking about before that was enacted, were they paying this tax?
So I don't believe that there is a specific comptroller ruling about Netflix, but there was a specific comptroller ruling about cable providers, which since before Westcott were
Cable providers don't create the content. Cable providers they're purely a delivery service of content created by other people. Right? Here you've got the content creator. I think Netflix is a good analog. I wonder if a magazine is another analog. I mean, they create all the content somewhere else. I subscribe to it. It's delivered to me. Do magazines that are written and printed in New York pay franchise tax based on Texas subscribers?
I believe that magazines would be taxed as tangible goods, which would be taxed based on the subscriber location.
So back to Netflix. Do we know anything about that?
So under that particular hypothetical, because this rule has existed since 1980, presumptively, although I don't have a tax opinion that I could point this to, it would be also taxed based on the customer location, which was confirmed again by the legislature in 2013.
But don't those amendments suggest that the legislature made that before those amendments it would have not been taxed in Texas? For example, if we look at 71103A2, it says each service performed in this state, and presumably that's performed by the entity that's being taxed, right?
Correct, Your Honor.
Okay, so if we've got to focus on that entity and not on the customer, because that's what the statute says, then it says, except that receipts derived from servicing loans secured by real property are in this state if the real property is located in this state. And my understanding is that was added to change the result in a particular case based on the ruling that the comptroller had made that would have said that those receipts would be sourced elsewhere for loans. And so doesn't adding that language and also adding these specific provisions for internet hosting companies to source those to Texas suggest that absent those special provisions, those receipts would be sourced elsewhere?
No, Your Honor, because the test
why isn't it surplusage?
So it is clarifying certain aspects of it. For example, the previous law, and I know that a number of you guys don't like looking at legislative history, but based on the description of the people who were advocating this law, they were doing it because there was some lack of clarity about, in particular for cable, about who the customer was. And so the law was added to clarify that the customer was the person in direct contractual privity. For internet hosting, there was also some lack of clarity about because it's a very, very hypothetical concept, what exactly was going on.
Was there a lack of clarity about servicing loans? It seemed pretty clear that under the comptroller's ruling, that was to be sourced elsewhere.
Your Honor, there were several changes. The laws regarding the sourcing of loan revenues and other financial services developed as, for example, Texas changed its laws about out-of-state bank branching, for lack of a better term, and so the laws were changed roughly contemporaneously. So there were external factors to the franchise tax that were also affecting that. But the general test that the comptroller is applying here actually derives from two cases that this court decided in the 1960s. Starting in 1962, because the 1959 Act does not actually define what the service is, let alone determine how you determine where it's located. But in 1962, this court recognized in a case called Van Zandt against Fort Worth Press that a service is a useful act performed at the instruction of another that doesn't result in a tangible property. More directly on point is Humble Oil against Calvert, decided in 1967, when this court said that in determining the irrelevant act for the purposes of the franchise tax, you look to two factors. One, what is the revenue producing act, or the act producing revenue, as I believe how this court actually said it. And the second is you look to the fact that the Texas legislature, unlike the 1966 tax compact that Your Honor referenced a few minutes ago, has opted for a single factor rather than a multi-factor apportioning scheme, because many states look to not just receipts, but also to property and to payroll. And this legislature has decided to use receipts only, which I think is telling.
So what if I hire a law firm, a Texas law firm, and I'm in litigation in California, and I say, I'm going to pay you $10,000 to file a brief in California. And they do all the work at a building in downtown Houston, and then they email it to their San Francisco office, who walks it down the street and puts it in gives it to the clerk. The receipt producing act is the filing of it with the clerk in California, I would think. But would you say that's it, and so that's an out-of-state, that's not taxed, or would you say all the legal work that took place in Texas is taxable?
Your Honor, anybody who's practiced law at a law firm for more than about 6 minutes knows that legal practices are segregable, and so you would actually segregate those out. And the work that would be done in Texas before the emailing would likely be sourced in Texas, because that was where it was performed.
But the receipt producing act was the filing with the, I don't care what they do in that building in Houston, as long as I'm paying them $10,000 to file a brief. That's the receipt producing act. Out of all these acts, that's what produced the receipt, is the filing of the brief, and that took place out of state. So
I think it might turn on the specifics of the legal contract, because most of the time, for example, if you were to have drafted the brief and been fired shortly before, still be able to bill for the work that you've already done, precisely because that work is segregable. But as by contrast here, Sirius has admitted both in the trial, both in the record and in their brief here, that their service is not segregable. They don't have a service unless they have a complete system, and that system is not complete until the programming is decoded here in Texas.
But is using the comptroller's straight ratio of Texas subscribers as a proportion of the revenue, does that fail to consider that there's a disproportionate amount of costs incurred outside of Texas to provide that service? In other words, how do you take into account that it's not just a straight ratio, that a number of the costs incurred to provide the service don't happen in Texas? Back to Justice Blacklock's example.
So in that particular instance, because this is a non-segregable service, we get back to the question that this court put in Humble Oil, where you have to determine the sourcing based on the legislature's choice to use a single method apportionment system. And I think that it was very telling that opposing counsel referred to, and I'm quoting here again, equipment and employment. Those track directly to the property and payroll that many states consider in their apportionment context, but that Texas has repeatedly rejected for the last 60+ years.
But just because they choose a single method doesn't mean the service is only performed in a single place, does it?
It does not. And so if this court were, as Justice Lehrmann asked, to decide that this service is performed in a series of steps, and some of those steps are in Texas and some of those steps are in New York, then you would start looking at fair value, which doesn't enter into the equation otherwise. Otherwise, you would just apportion it based entirely on the service.
And so if we were to look at it that way, would we just have to send all this back because neither side is looking at it that way?
No, Your Honor, because as this court recognized back in 1955 in Calvert against Union Producing, it was Sirius's obligation to show what the fair value, that it was their obligation to show they were entitled to a refund. And they've gone all the way through trial. So you look at their evidence and you determine whether or not they met that burden. And we respectfully suggest that they did not. Because, as we've explained in our briefing, there is a disconnect between cost and fair value. They have asserted that cost is a valid interpretation of that fair value, and we don't dispute that. But their own authority establishes, and I'm looking at Religious Hearts of Texas against City of Houston, which involved Duchesne Academy, the cost is what you look at when there is not a comparable market transaction. At the time of trial, there were 33 million comparable market transactions every month, and that there were 33 million subscribers. Sirius determined its fair value of its services when they set the subscription fees. That is the fair value at issue. That's what the third court held. I believe they actually got into that issue correctly. And as a result, it comes in this pretty rare circumstance that looking either at fair value or at straight up apportionment comes to the same conclusion.
So in this administrative rule about services performed both inside and outside of Texas, do the words performed and rendered mean the same thing or different things?
I'm not sure if I believe they mean the same thing. We haven't seen any dispute that they don't mean the same thing, and I can't think of a reason. There might be contexts where they don't, but here I believe they would mean the same thing.
You're trying to apportion things based on the location of where the service is performed. It all just collapses back into where the service is performed.
Correct, Your Honor. So the question here...
So the only way that your approach succeeds is if the entire service is the delivery.
No, Your Honor. The only way that their approach succeeds is if the decryption is not part of the service. Because when asked about the services and when he was discussing the services provided in Texas, my opposing counsel...
The comptroller's position is that they should be taxed as if the entire service is the delivery in Texas.
Yes, Your Honor.
Okay.
But we have also argued in the alternative that the fair value is determined based on the subscription costs, and that as a result, even if you were to consider for fair value, the fair value of the service is, and they've admitted that they can't divide it out between different pieces because it's a non-segregable service, that's why you get to the fair value that of the two of them are...
Well, but if they're right about what the law means, then you would have to look at how much of their studios are in Texas versus how much are somewhere else, because if the service performed is the creation and distribution of the content, then wouldn't you look to the percentage of that takes place in Texas versus other states, which is...
If the entirety of the service that is performed is the creation of the content, that would be accurate. But if the service includes that decryption element, and I would point this court to its language in Van Zandt, where it said that services may be rendered through though the actual labor be performed by one's employees or by means of his machinery or other equipment. That was decided in 1962. It would be distinctly anachronistic to go back and say now in 2021 that it can only be the actions of their actual employees. But if the court were to decide that that was the only part of the service, then yes, we would have to consider which part of the content is created in Texas and which part of the content is not. If, however, the court were to continue to maintain that some of that service is the decryption that Justice Bland was talking about a few minutes ago, then you have to get into the fair value analysis, and they have never tried to describe the fair value of that decryption, even though their general counsel and longest serving employee testified at trial that, and I'm quoting here as well, that the decryption is critical to their business model because they are selling conditional access to that
critical
content.
to their business model because if they didn't have it, people wouldn't pay for it because they could get it for free.
I'm not sure I understand which is the
Decryption is something that's important to Sirius because if they don't decrypt the content, people that have the right kind of equipment will not pay a subscription. They'll just be able to get it for free. So they're protecting their own business model by having decryption, which makes me think that the consumer isn't getting a whole lot of value from decryption. It's Sirius that's getting value from decryption. It's protecting the thing that they're trying to sell.
The only way to decrypt and therefore hear Sirius's radio is through a proprietary chipset that Sirius developed and is continuing to develop. So as a result, it's critical to their service in the way that you just described, but it's also critical because the listener simply couldn't hear it. There's no other equipment.
What if Sirius were to say, we're going to have two things we're going to sell you. We're going to sell you access to content, but good luck if you don't also buy our decryption package, which we'll give you for $1 a year. Would that, if they structured it that way, would we have a very different argument or not?
Under that circumstance, you'd have a very different argument, but I don't think you'd have a service because as multiple witnesses testified at trial, nobody would pay for the music if they couldn't hear it.
So you'd probably buy both packages.
Correct.
But we'd have two different bills from the controller.
Correct.
One would be the tax on the dollar for Texas chips, and the other would be, as we've just been describing, the allocated tax on the production of the content, which I assume most Sirius subscribers think that what they're getting is content and not decryption, even though obviously they need the decryption.
Correct. They are purchasing a package of decryption and content, but the decryption is the last act performed, although based on a piece of technology. And in fact, another one of their witnesses admitted it was the last act performed.
Why does it
That's
matter that
decryption.
much if it's the last act performed? Where does that come from exactly?
So that comes from the fact that the legislature has chosen a single factor apportionment scheme that does not take into account property and payroll. So that's a choice that has been well known to the legislature for decades. In fact,
So if we talk about legislative acquiescence, why haven't they acquiesced in the Westcott case as opposed to in some, administrative law judge's obscure ruling in 1980?
so the Westcott case, contrary to what my colleague described it as darn near identical, involved a different service. There, the service is education for licensure, which included broadcasting for certain types of the education, but included a package of other things, including, for example, question and answer periods afterwards and grading of tests. And so the last act performed was not, in fact, the broadcasting or the decryption. That's what the third court concluded and expressly distinguished in that case the existing rule regarding cable television that had been in existence before 2003.
Just to be sure that I understand your position, if we think that the service the service doesn't have a single place but could take place in multiple locations, your position is that then we go to the fair value test but we have to apply it on the existing trial record, and because there's not enough evidence for Sirius to carry their burden to show that the tax should be different under that approach, then the comptroller wins. Is that correct on this particular record?
Yes, Your Honor. And
Why wouldn't we defer to the trial judge's conclusion that the value of the decryption service provided is negligible in comparison to the other services provided? In other words, is this just a disagreement about the value of that service in a fair value analysis? And if that's the case, why don't we accord the trial judge some deference?
Your Honor, that's not my understanding of the trial court's finding of fact. The trial court made a conclusion of law that the end product revenue producing act was the correct test, but it made a finding of fact that that end product act was the production of content. And so there wasn't that analysis of what the separate fair value of the decryption was. They agreed with Sirius's view of the actual service, which is what we are asserting was a legal error and therefore not entitled to deference.
So I don't feel like I got an answer about the lawyer, so I'm going to ask about an accountant. What if you pay an accountant to file your taxes? You pay them a flat fee, and they file your taxes, and they do all the work in Texas, but the filing of the taxes takes place on a computer in Washington, D.C., and that's what I'm paying for. That's the end product. Receipt Producing Act is a transaction on a computer in Washington, D.C. Is there tax on the service that accountant provided to me in his office in Texas?
So I'm not necessarily following the distinction that you're making. The act of
I'm
filing.
asking how that's taxed. Does that accountant pay tax on that service, or do we look to the Receipt Producing Act, which is a transaction on a computer in Washington, D.C.?
So like lawyers, accountants typically bill their time, and so they would be billed, they would be apportioned.
I pay him $10,000 to file my taxes.
So when they're physically filing the taxes in D.C., then under that unusual set of circumstances, it may be that the actual end product act is the filing of the taxes, but it also might be the situation. I would
think a lot of accounting firms would like to know that, and they could then, I think they'd pay a lot less franchise tax if they could structure tax filings that way.
Your Honor, what I was about to then say, but that may be the rare circumstance where it's a multi-step process that requires fair value. The In Producing Act test applies to most services because as Sirius actually admits that the question of the nature of the service doesn't come up that often, and that and focusing on a single act gives a single locus for the tax accountants and the auditors to look at, and therefore save the more detailed and fact-intensive question about fair market value of services to the rare instance where it's actually performed in multiple locations. For most accountants, the service will be performed on an hourly basis, like most lawyers, and it would be apportioned accordingly. Under the flat fee circumstance, that might be a different question, but that goes back to what the customer's paying for.
Any other questions? Thank you, Ms. Pettit.
Thank you.
Mr. Friedman, you have 5 minutes.
Thank you, Your Honor. This is a pretty simple, straightforward regime, Your Honors. It's 2 pieces of authority that we're applying here. One is the statute 171-103A2, which has not changed since 1959. It has not been legislatively amended or changed in any way in more than 60 years it's been on the books, and it looks to where the service is performed.
And if we conclude it's performed in multiple locations, and that's the position that neither side is taking, what do we do then?
No, we are saying it's performed in multiple locations, Your Honor. We look to the the controller's rule, which was in place at this time.
Excuse me, if we conclude that the chips are part of the service, the decryption is part of the service, what do we do then?
It's not the chips, Your Honor, that's relevant here, because that's not Sirius XM.
I don't want you to argue with my hypothetical.
Okay.
I'm just asking if part of the service is performed with decryption in Texas, what do we do then?
So then we look to the controller's rule that was in place at the time, and that rule reflects a fair value standard without any more definition as to what that meant. So we had the burden at trial to show the fair value that we engaged in of our service in Texas versus all the other jurisdictions where we engage in our activities. And we did that. We did that through expert witnesses, and we did that through fact witnesses.
So I'll find an expert report that says, here's the value of the decryption in Texas?
You will find a report.
Okay.
Sorry.
Go ahead.
I'm sorry. We produced a report and evidence and testimony that showed the amount of activities we engaged in Texas, and we identified all of our activities in Texas, and we assigned a value to them.
Did it deal specifically with the decryption?
It did, Your Honor, but let me address that just a little.
Did it segregate that?
Yes, it's in our expert's analysis in his Excel spreadsheets that he presented at trial that Judge Jenkins got to ask questions regarding, and he did. And in that analysis, the decryption activity, I just want to decrypt our decryption discussion here today. Our decryption activity is engaged by Sirius XM outside of Texas. It's not here in Texas.
But if we disagree with you on that, then what numbers do we look to decide how much of it happened in Texas, if any?
Well, you would look toward the taxpayer's performance of its services and its activities, and you would assign a value to it using the controller's rule.
And it's your burden to do that, and if there's nothing in the record that assigns a value in Texas to the decryption, then you failed to carry that burden? We
assigned a value to our distribution of our activities that included the ground stations, the satellites, which Judge Jenkins took objection with, you saw in his decision, and the decryption activity, and we decrypt our activity. The signal is encrypted, and then the cars decrypt them. The cars that are decrypting them are not our activity, it's not our equipment, it's not our people.
I understand that's your position, but I'm asking you, if we disagree with you about that, then have you still carried your burden to show that you owe a lesser amount than the comptroller has said?
Yes, of course, Your Honor, we did, because any activity associated with those chips that are in cars here in Texas, we engaged in activity with the car manufacturers, and that's included in the study.
What is your response to the question that I can't remember who asked, but it has to do with remanding the case? And the answer was so that to get evidence about that, exactly what's the segregation of the decryption, which would favor your client, and what is your response to their answer to that?
Yeah, remand is unnecessary here, Your Honor, for a few reasons, and let me go through them. First of all, we presented a very robust case, which included a lot of fact evidence that Judge Jenkins relied on in reaching his conclusions, and that would be subject to a very high standard of review, number one. Number two is regarding the actual analysis and the calculations, all of that was presented at trial. That's all in the record, including in Mike Starkey, our expert witness, and Mike Starkey's report would be the second reason. The third reason is, I think, this kind of misunderstanding about decryption and encryption. We encrypt our signal. The cars decrypt the signal. The cars do the decryption owned by our subscribers. We do not engage in any of those activities here in Texas.
If we were going to take Justice Blacklock's example about the accountant doing the work somewhere else and filing in Washington, D.C., if the accountants received a $200 filing fee upon the filing every time, there were, in addition to the work that they did in producing the tax return, would some fair value be attributable to that activity in Washington, D.C.?
Yeah, it's a very straightforward example, and it's actually covered in the revised rules, so I was surprised about the confusion associated with it. So a very clear example regarding a tax return preparer in Washington, D.C., preparing a return for a Texas resident, Texas customer, let's say, client, then all of the activities of that taxpayer would be reviewed. If all of the activities of the taxpayer were engaged in outside of Texas, then none of its activities would be attributed to Texas, obviously. If for some reason it was a big four accounting firm and some of the activities were engaged in Dallas or Austin and some of the activities were engaged in Washington, D.C., you would use the rule in place at the time, the fair value rule, and look to see how much of those activities were in Texas versus how much of those activities were in Washington, D.C., and presumably you'd look to the effort used to prepare that return.
Quick question, if I may, Chief.
Yes.
I found your Exhibit 3 to be fairly striking, but Ms. Pettit suggested it's somewhat deceiving because Westcott involved a lot more than the mere production and distribution and then final decryption of the information. Would you respond to that very quickly?
Yes, Your Honor. The facts are what the facts are in that case, and they're pretty straightforward, laid out in that Court of Appeals decision in 2003, and our Exhibit 3 demonstrate those. There is one fact that we did not include in our Exhibit 3 that I think is kind of relevant for purposes of the discussion that we're having here today, and that is Westcott, which was headquartered here in Texas and engaged in its production of content here in Texas and its distribution of that content here from Texas. And the controller took the position that all of those were the relevant activities for purposes of determining this question, the creation of content, the distribution of content. The actual decryption, the handing off of the content, if you want to think of it that way, around the country to police departments, mostly throughout the United States, was done through equipment that Westcott owned. It's in the case that Westcott owned. A customer needed to acquire equipment from Westcott and install it so it can catch the satellite signal. Westcott owned that signal. So when that customer ceased its service, Westcott would go in and retrieve that equipment from the subscriber because Westcott owned it. It needed to give that equipment to that customer so that it could receive its service. That's not our facts. Our facts are we don't own any of the decryption equipment here in Texas. That's all owned by the car owners. Other than that, Your Honor, the cases are on all fours, and I think the cases speak for themselves. You can't reconcile them.
Any other questions? Thank you, Mr. Friedman.
Thank you, Your
Case
Honor.
is submitted, and the court will take another brief recess.
All rise.